I'm not inclined to accept this plea agreement, and I can make a detailed record as to why. Over the course of the last 3 days, I've read 33 filed victim impact statements. The plea agreement for an infraction does not seem reasonable, no matter the age or the situation of the defendant.
Mr. Dieters filed a Rule 11 plea agreement in the case. And that's what we would like to address today.
All right. Do you want, Ms. Wadehofer, you can have a seat there. I can start. I'm not inclined to accept this plea agreement, and I can make a detailed record as to why, if you all would like me to start.
I would like to make a detailed record as to why the court should support it.
Certainly can't, but I'm not accepting this offer. And I'll tell you, I've handled cases on that side, and I understand mitigation, aggravation, but I am not accepting this plea agreement for an infraction. So I'm going to start here and explain for detailed reasons as to why. Over the course of the last 3 days, I've read 33 filed victim impact statements. And I'll just start by saying, I want everyone involved to understand that I read every single thing that's filed, and I have reviewed these. I reviewed about half Monday and then frankly had to take a break and go home. The plea offer that was filed suggests that I should accept an infraction. The counts in this case, there's 3 counts. Count 1 is careless driving causing serious bodily injury to Isai Aguirre. Count 2 alleges careless driving causing serious bodily injury to RF, a child. Count 3 alleges careless driving causing death to Ms. Haley Aguirre. So the counts allege a death and 2 serious bodily injuries. The plea agreement for an infraction does not seem reasonable, no matter the age or the situation of the defendant. And I do not know much about the facts of this case. This is an infraction, or this is a misdemeanor summons and complaint. But reading victim impact statements, I have deduced or figured out kind of what's going on. And a lot of the victim impact statements even recognize the mitigation for Ms. Wadehofer. But a lot of the victim impact statements also recognize the aggravation of what an infraction really is. An infraction puts it on the court to impose a maximum possible penalty of a $100 fine. The question I have for Mr. Bacchus, who's counsel on behalf of Mr. Aguirre, the alleged victim, is there a true benefit or value to the court accepting this plea that I may be missing?
No, Your Honor. There is no value in accepting an infraction under these circumstances. In fact, as I told the district attorney, the elected district attorney herself, in more than 30 years doing this, I have never seen a district attorney's office offer an infraction under the facts and circumstances in a situation like this. This is the most outrageous offer that I have ever witnessed. And there's no basis for it at all, really. We're at a loss.
Okay, so the things that the court can address and cannot address with an infraction are as follows. An infraction allows for no restitution to be ordered. A conviction for an infraction is not a conviction for restitution purposes. And one of the things that I deduced from reading these victims' impact statements, there's definitely a restitution issue here. For example, referring to Ms. Vanessa Carrillo's statement, Ms. Aguirre's mother, she discusses overall the financial impact, but she cites specific restitution issues with regard to her grandson's broken leg, and the fact that that required multiple surgeries. She also cited specifically, but they have gotten the child into counseling. Those are both specific examples of restitution. And that's a purpose that the court needs to address, and it just simply cannot be addressed through an infraction. An infraction also, as I said, allows the court to do nothing but impose a $100 fine. There's no imposition of public service. There's no probationary period. There's no opportunity for the court to order restorative justice or mediation. And that's another reason I am rejecting this plea. Again, I do not have affidavits. I do not have facts, but I'm deducing what happened in this case. No public service hours. Public service hours are a way to honor and respect the victim in the case. Ms. Aguirre's cousin, Ms. Romero-Ricks, Ms. Sales, another cousin, kind of touched on this in terms of giving the court a picture of who this person that is no longer present, is no longer alive, sorry, what the court should consider about trying to at least craft an acknowledgement of that life and that loss of life. Ms. Savannah Camacho and Ms. Soraya Camacho also. These are younger ladies. One is a senior in high school, and these are very articulate young ladies who talked about wanting the court to consider not necessarily punishment or retribution or even jail, but consider what it means to accept a plea agreement and what kind of sentence should be imposed. I checked in with counsel for the victim, and I just don't see the benefit here to the court taking an infraction. Of these 33 victim impact statements filed, 32 of them were big picture, trying to explain the impact, the effect, explain who Ms. Aguirre was to them. And she was an important person to her family, her friends, her coworkers. I can't recall receiving this many statements and the breadth and depth of these statements. There was one outlier, and I state this on the record, and this is from Ms. Maribel Mendoza. Ms. Mendoza is processing through this. She is angry, which is a natural reaction. This is an unnatural thing for a child to predeceased parent. It's just unnatural. But I understand that anger. What it resonates with me is, though, I have to look at similarly situated defendants and similarly situated cases. And I have had a case sentenced, please turn your phone off. Someone has passed away, and we're going to give that the respect it deserves. Thank you, sir. You should have. Yes, sir. You're sitting there. You're not a party to the case. I know you're a supportive person, but this is an important proceeding. And let's try to give it the dignity it deserves. That's something that these letters reflect over and over about what it means to take responsibility, what it means to have a system that recognizes what's happened. So please, thank you for turning the phone off. But that's how Ms. Mendoza explained it. And so for me, what I'm thinking of is, I'm thinking just back to a recent case, also a tragedy, a single count of careless driving resulting in death, a young man who the case involved similar mitigation, similar aggravation. That young man pled to a single count of careless driving resulting in death. I ordered a pre-sentence investigation. I imposed a probationary sentence. I did not impose jail, but there was a process for the court to consider similar mitigation and aggravation factors present. So for those reasons specifically, and that last point, not only in Ms. Mendoza, but Mr. Aguirre's second statement, which was one of the last ones I read, it was this morning, number 32 in my chart. The court should consider an outcome that would have that recognizes the reality of this loss and still very likely receiving no jail time. A traffic infraction is just not appropriate. And frankly, that's well stated. And that's why the court's rejecting the traffic infraction plea agreement.
Judge, I think that the court makes incredibly good points with respect to the impact on the community that this incident has caused and the impact on the people that loved the victims. I certainly take that into consideration. I will tell you that Mr. Barnott has spent many, many hours going through the evidence in this case, talking to the troopers. And I have spent much time with him, specifically related to whether or not the people would be able to proceed in proving beyond a reasonable doubt the elements that were necessary in a careless causing death case. I would note that the people do not believe they have a likelihood of success at trial on the careless causing death. Certainly the mitigation on the effect is really important for the court to consider, but we don't get there unless we can prove the charge, Judge. We've spoken with the trooper in this case, and he also agrees with our assessment that it would be very difficult for a jury to find that the defendant in this case drove carelessly when there was simply no information to suggest that there was any pre-warning or information that would have led this defendant to have made a different choice rather than to drive. There was simply no way for this defendant, in my opinion, based on the information that I have, to have prevented a physical reaction to her body that led her to do the thing that happened. But again, that in no way takes away from the incredibly devastating damage that has been caused by this incident. But Judge, in my prosecutorial discretion, I do not believe that we can prove a careless causing death case, and that's something that I've discussed with Mr. Bacchus. Mr. Bacchus and I disagree on that. I believe that Mr. Bacchus obviously has his civil case that he's filed, and a lot of the responsibility and accountability that Mr. Bacchus is seeking, we simply can't seek in criminal court. And so in order to mitigate, and again, Mr. Barnett and I have gone back and forth with how do we resolve this case in a way that reflects that the car went into the other lane, and understanding the fact that I do not believe a jury would have found that this met the requirements of careless driving. How do we mitigate that? Judge, the only other option for us is to dismiss the case because, again, ethically, I do not believe that we can prove this case beyond a reasonable doubt.
And Ms. Kelly, that's the prosecutorial discretion. But this is, in my opinion, this is almost more confusing to the family.
Sure.
For me to accept an infraction which does not allow for any restitution, no public service, no probation, no restorative justice. And so I understand, as a district court judge I appeared in front of, told my colleague one time, if you want to be the district attorney, you be the district attorney. If you want to be a judge, you be a judge. If you want to be an attorney, you be an attorney. I understand that, but I am not accepting an infraction. What you're raising, Ms. Kelly, is factual questions that I do not have access to. As I made very clear, I know almost nothing about this case other than the charges. I am deducing facts because I read 33 victim impact statements. But frankly, Ms. Wadehofer pleading to an infraction is just not an agreement that I'm going to take.
I understand that, Judge. And if I could have a moment, the challenge here is that the parties that have reached this agreement are the parties that have knowledge of the facts and the parties that have knowledge of the circumstances. And so I think what I'm here to just suggest is that because we have spent so much time with these facts, and because we have spent so much time in the question of whether or not we can prove the case, I'm asking that the court trust the negotiations and the discussions between the parties who are familiar with the actual facts that would be presented to a jury. And in the alternative, Judge, unfortunately here, is a dismissal of the case. And I'm not sure that the victims would feel any better with that resolution. And so there's the challenge. And I just want the court to be aware that—
Ms. Kelly, I'm aware of it. This is not my child. Believe me, I know, but I'm not going to make the district attorneys. If I accept this agreement, it does nothing. I've thought long and hard. That's why I asked Ms. Is there some way I can accept this? Is there some benefit to the infraction?
And Your Honor, could I be heard for a moment?
Mr. Bacchus thinks there's a benefit because that would help him in his civil case. Is that what you were going to say, Mr. Bacchus?
No, absolutely not.
And that's, Ms.
No,
Kelly,
no,
this is,
no, that's-
hold on,
that's-
counsel, both, I'm the judge.
Yeah.
Whether you like it or not, you're stuck with me as the judge. And believe me, again, I've been doing this long enough. There's attorneys that are glad I'm the judge, and there's attorneys that don't want to be stuck with me. But this is the nature of an imperfect system. So I really don't want Ms. Kelly and Mr. Bacchus to start talking over one another or arguing about this. But I will tell you, Ms. Kelly, that was something I had lined out when I was preparing for this. And I checked in with Mr. Bacchus specifically as attorney for the victim. And the way I framed it is there some true benefit or value to the agreement that I may be missing? For example, restitution, or I know, yeah, there can be a civil case, but I'm looking for a benefit to what I'm doing here. And I'm not persuaded based on this. I don't know what these troopers will say. I've had Ms. Wadehofer was appearing virtually until the last court appearance, but this is set for trial. I set a 2-day trial. There was a discussion of, to use kind of maybe an inartful term, there could be a battle of experts or different expert opinions. And that's what I've tried to do, is manage the case. Attorneys try to get me to take sentence steps all the time. And I generally say, well, I'm the one responsible for this. And yeah, it could result in a dismissal, but I'm the judge. I'm not the district attorney. I'm not the defense. I don't have information. And, I will be able to explain the decision that $100 fine is the very best I could impose. And I'm not comfortable with that disposition based on the information in the record I have. Again, there's no briefing, there's no filing, there's no facts other than what I've heard today. And I'm not going to change off the seat of my pants because attorneys want to argue about how they're seeing things.
Judge, may I ask just a brief question?
Yes, Ms. Kelly, what's the question?
What I'd ask in defense counsel, I haven't asked defense counsel this yet, but would the court be open to reading and hearing the information that the district attorney and defense counsel have in this case? In other words, do you have any preference of setting this over in order for us to provide you with the information, at least that we've been considering?
It's not appropriate for me to read that other than in the filing of a brief. But again, an infraction it just doesn't seem reasonable no matter the age or the situation of the defendant. Again, I am not commenting. Okay, if the question is, do I want to read everything? No, it's not my role. So I've made my decision on the issue before me today, which is whether or not the court should accept an infraction.
Your Honor, could I just make a statement?
Yes, Mr. Bacchus.
Thank you, Your
counsel.
Honor. On behalf of the victims, we 100%, 1000% support your decision not to accept this plea. It is the right thing to do. It is the just thing to do. In my conversation with the district attorney, they were unwilling to explain any investigation that they've done. When I asked whether they had looked at any medical records, spoken to any experts, issued any subpoenas, done anything to investigate this fatality case before offering this, I was told they had not done those things, that they had one letter that they received from the defense counsel. They had not spoken with the physician who wrote the letter. They had not made any attempts to do anything. I offered, at least based upon the representations to me, I offered to be appointed as a special prosecutor, that I feel like I would be happy to take the case. I suggested that the case be, I asked them to switch the prosecutors on the case. I did not believe that the prosecutor assigned was being unbiased in his approach to looking at this. And I reiterated direct directly to the district attorney, who I had to reach out to. This district attorney did not reach out to the victims. I reached out.
That is a lie, Mr.
Just keep
Bacchus.
going.
That is a lie.
Okay, but now, there we go. We're done. Ms. Kelly, I'll remind you, I brought this up a couple times recently to counsel in open court. There's a civility order in this district. The use of the term liar, it's unacceptable from witnesses. It's certainly unacceptable from officers of the court. I'm going to take this down a notch. This is an infraction. I understand it. And everyone is raising big picture issues, which if I don't accept this, it may mean the state dismisses the case. I hear that. But I'm going to not accept it because I've thought and I've tossed and turned about if I accept it, that's what 32 of these 33 statements say. It's almost like a slap in the face to who this person was. The depth and breadth of these statements. I mean, I am not blessed with this kind of family, but I'm not going off of emotion for who this person is. I'm going off the legal reasons I said. No restitution, no public service, no probation, no restorative justice or mediation. A similarly situated case, which I didn't impose jail, but at least the court did something to stay in its lane and do its purpose of considering what's important in terms of what is fair. No more, counsel.
Thank you, Judge. I want to make the record clear that we are in full compliance with the Victims' Rights Act. We have been from day one. Second,
Yes, and the court
we would ask
will
for-
note,
yeah.
hold on, Ms. Kelly, may I please I will make that record. That's an inappropriate statement from Mr. Bacchus. And Mr. Bacchus, I will tell you, I can show you by video WebEx. I have a brain that works a certain way. I have a grid and I have gone through these 33 Victims' Rights Act statements. Now there's some confusion by Ms. Mendoza. She thinks the court wants everyone, and she was actually, that's part of the anger. How can the court expect this? I actually accept it. I understand it 110%. Someone wrote in here, what would you, for me to think about my family? I can't do that. That's improper for a judge to do it, but I get it. And so, Mr. Bacchus, the Victims' Rights Act, there's compliance. Because I'm reading all these statements and I've been reviewing them and I've been electronically sending them to Mr. Dieters, Mr. Barnett, and I believe also you. So that's what set Ms. Kelly off. I'm not condoning her response, but I understand why she had that response because that was a bridge too far. Mr. Aguirre, let me start with you. Are you there? Could you hear the proceedings?
Yeah, I'm here.
Did you want to make any statements on the record?
Your Honor, my name is Isai Aguirre, and I am here today as a husband who lost his wife and as a father of 4 children who were in that vehicle when their mother was killed. Okay. On July 12, 2025, my wife died because the defendant fell asleep behind the wheel and crossed into our lane. Our children were catastrophically injured. Their lives will never be the same. And my father was also in that car. He matters too. And yet today I'm standing in this courtroom being told that the ends with the traffic infraction, a ticket, no acknowledgement for the life that was taken, no acknowledgement of the severity of my children's injuries, no acknowledgement of the reality of what happened on that road. Just a fine. I do not hate the defendant. I do not believe she woke up in the morning intending to harm anyone. And I have heard about her battle with breast cancer, and I do not minimize that. I truly don't. But illness does not erase responsibility. We all know that treatments and medications, especially for something as serious as cancer, come with warnings. Drowsiness, dizziness, blackouts. We are told not to drive when those risks are present. Those warnings exist to prevent exactly what happened to my family. How do I explain that to my children? How do we tell them this is what accountability looks like? Where's the accountability here or the integrity? I have tried to put myself in the defendant's shoes. I truly have, but I ask this court, has anyone put themselves in my shoes? My wife matters. My children matter. My dad mattered. And this case matters. I'm not asking for revenge. I'm just asking for responsibility. Thank you, Your Honor.
Thank you, Mr. Aguirre. And as I said a couple times, I've been working in this business a long time, and there are certain cases where I just know that the adversarial system of justice that we have in this country, it might be the best system in the world, but it's not perfect, and it's not going to properly resolve the issues. And I made the decision today to try to recognize that. I would encourage you to continue to talk to your attorney because there could be value to this plea, but based on what I have today, that was where I was saying, no, I don't see it, and no, I'm not going to do it. And I'm not going to be convinced super quickly. But there could be value to this. If I don't take it, it could result in the case being dismissed. This is a criminal case. It's proof beyond a reasonable doubt. And I hope you hear me saying that I'm not accepting this and this could result in, and not, but I hope you understand.
Yes, we understand.
We understand, and that's the only thing I want. It's just to get to the bottom of it. And
Okay. I appreciate you
that's
guys
it.
being
And
here.
if it gets dismissed, then oh well. But at least we fought for it. We
Yes,
fought
sir.
for it. That's it.
And I'm sorry, as I said before, there's certain cases that just, there's no way to properly fix what happened. Your daughter was amazing in terms of like who she was as a person. And that's where I'm focused on in terms of what I can do and how does an infraction bounce off of me. And I just want you to hear that.
Thank you.
Sorry, Mr. Dieters, I wanted to just compliment some of the statements recognizing empathy, sympathy, and compassion towards Ms. Wadehofer. You know, those are people who have lived a life, who understand that there's always going to be some questions that are unanswered and things like that. But I compliment those. And I recognize the mitigation to Ms. Wadehofer. I recognize the aggravation to your family. And those are just legal terms that really mean how it feels to you and how it feels to her. And it's hard. So again, I apologize. I'm sorry for your loss, man.
Thank you. Appreciate it.
So I want to give you enough time. Ms. Kelly suggested like a couple weeks. Does that sound reasonable?
Sure. Judge, if I'm not going to make a long record, but sure, you can imagine my angst over the irregularity that we now find ourselves in.
Oh, it's not that irregular. Judges, like I ran this by some colleagues, and a couple just very bluntly, I said, you know, I need to process through purposes of sentencing, possible penalties, and the court can reject a plea agreement. That's all I'm doing. And I'm acknowledging like Ms. Kelly was super plain that, you know, if I do this, then she has to do her job. And that's why I really stepped in. And I do respect that. The district attorney has a difficult job. Defense counsel has a difficult job. I would say I have a difficult job. And so I'm not taken away from that. But I want the message to be, I'm simply rejecting the plea agreement for a traffic infraction for the reasons that I tried to explain. And it's nothing personal towards anyone. It's based on the legal principles that I believe are in play in terms of sentencing options. And all right, Mr. Buckus, any final record? I think you were the last attorney. Anything or no?
Thank you, Your Honor. Just very briefly, and I'm not going to get into any substance. I just want to clarify because I didn't get the chance to finish a sentence just to make sure. And it is true, I came on the case late. I don't know what communication this district attorney had with this family before I came on and entered an appearance in the case. Once I entered an appearance, I can only be reflective of what happened after I entered an appearance, just for clarification of the court. We appreciate the court's time today. This, Your Honor, what you have done today is a measure of justice for this family. Your position today in not taking this plea is very important. It's very important to the system, and it's very important to the family. And on behalf of the family, we could not thank you more for refusing to accept this plea, regardless of the collateral consequences that may come next. This was the right decision, and we really appreciate it. Thank you.
All right, let's find a date in a couple weeks